Oftentimes, when two companies have a serious enough dispute, they turn to the court system. It's a process that should, in theory, bring about justice. Sometimes that justice is served. Sometimes it isn't. And apparently, sometimes even when it is, it still isn't. Walking out of the Florida courthouse on an August afternoon in the year 2000, Nicholas Stratkic and Edward Russell had a good reason to be happy. They had sued the Walt Disney Company and just won $240 million. Or so they thought. Edward Russell was an architect from New York who had experience with sports projects. And Nicholas Stratkic was a former baseball umpire from Ontario with a passion for sports. In 1987, the two had founded All Pro Sports Camps Incorporated, with the hopes of designing and planning year-round sports camps for children. They certainly didn't lack ambition, because the following year, in 1988, they decided to go big by pitching a project that they felt would be perfect for Walt Disney World. Their idea was a 150-acre sports complex called Sports Island. It would feature fields and stadiums that could be fit for 30 different sports. The general business plan would be that Disney would lease All Pro the land, but design and build the complex themselves, as well as provide hotels and transportation. All Pro, meanwhile, would be responsible for raising the financing to build Sports Island and would then manage and operate the complex after it opened. Now, according to All Pro, they reached out to Steve Wilson, who worked with the Walt Disney Company as a golf executive, since the resort has multiple courses. After discussing the idea with Wilson, he allegedly set up a meeting for them with one of Disney's key architects, Wing Chow. It was there that All Pro claims that they offered Disney a 350-page business plan, 200 preview slides, and a 150-pound scale model of the proposed facility. They claimed the meeting went well and that Chow liked the idea. So All Pro continued to develop the concept and even went as far as beginning their search for corporate financing. However, things came to an unexpected halt in February of 1989, when All Pro received a rejection letter from Disney that stated, quote, "Our plate is full and consequently can't entertain such proposals for some time in the future." According to All Pro, they were never given back the 350-page plan book, 200 slides, or the scale model that they would later value at $200,000. It seemed like an opportunity that simply came and went. They tried for the big fish and failed, and, sometimes it's just bad timing. Then, 4 years later, Disney announced that they intended to build a $100 million sports complex on Walt Disney World property, with a planned opening date of 1996. Stratkic and Russell began to notice that more and more of the complex's details lined up with their old pitch for Sports Island. And that's when they decided to sue Disney. In 1994, All Pro Sports Camps Incorporated sued the Walt Disney Company, Walt Disney World, and the Disney Development Company in federal court for copyright infringement, claiming that the design for Disney's upcoming sports complex was lifted from their Sports Island pitch. It was a misstep on All Pro's part, because after 2 years of lead-up, the federal judge dismissed the case. She ruled that no reasonable jury could find the All Pro plans, layout, or architecture to be substantially similar to Disney's. The two walked away from the loss, figuring that the issue was the manner in which they sued Disney. So in 1997, they tried again. This time they brought the suit to the Florida State Court, and they sued Disney for theft of a business idea, as well as fraud, theft of trade secrets, breaking an implied contract, and breaching a confidential relationship. The idea was that it would be easier to prove these more specific claims than it clearly was to try and argue copyright infringement as a whole. All Pro, perhaps thinking quite a bit of their idea, was seeking $1.4 billion in damages. Cases like these tend to take a long time, and so it wasn't until July of 2000 that the trial actually began. All Pro claimed that there were 88 similarities in total between their plans for Sports Island and what was, by that point, the ESPN Wide World of Sports. For instance, they highlighted that the pitch for their complex involved having facilities to support specifically 30 sports, which is the same number of sports Disney claimed their complex would also support. They also noted that the two plans not only featured the same number of football fields and soccer fields, but both had plans for baseball stadiums with exactly 3,000 parking spaces. All Pro also had the testimony of Steve Wilson, who had admitted that he had intimate knowledge of the Sports Island plan and acted as an intermediary between All-Pro and Disney executives. And while Disney did reveal that they reprimanded Wilson for violating their company conflict of interest policy, they still assigned him as a project coordinator while developing the Wide World of Sports. On the flip side, Disney claimed that they were planning a sports complex years before the Sports Island pitch. Former NFL linebacker Reggie Williams, who Disney had spearheading the ESPN Wide World of Sports project, testified that he had no prior knowledge of Sports Island. Furthermore, Disney architect Wing Chow testified that he had no recollection of the Sports Island meeting back in the 80s. Even at the top, Disney CEO Michael Eisner claimed that he had never even heard of all-pro sports camps until that very deposition. Disney's general counsel, Lou Meisinger, argued that, quote, "The only arguable similarity is that Disney copied the idea for a sports theme park. That idea is as old as ancient Greece and belongs to the public." Yet there was some pretty damning evidence. As All-Pro's lawyers pointed out, Disney provided their copies of the Sports Island plans during the discovery phase of the lawsuit, which means somebody at Disney did see the plans for Sports Island and went as far as either keeping or making copies of it. When questioned about it, Disney executives had no recollection over who copied the plans. The trial lasted a month, and after both sides gave their closing arguments, the jury of 6 spent 2 days deliberating. After those 2 days, they delivered a unanimous guilty ruling on 6 of the 7 charges and awarded All-Pro $240 million. Not only that, but they ruled that Disney's conduct was willful and malicious, which meant that a judge at a later hearing could triple the award if they chose to. Disney, unsurprisingly, vowed to appeal the ruling, and even went so far as arguing that the $240 million valuation of the award was unreasonable because the ESPN Wide World of Sports technically wasn't profitable at that point. That November, a circuit judge upheld the verdict, and so Disney took the ruling to the 5th District Court of Appeals. Now, this is where a legal ruling can turn into a Pyrrhic victory. Appeals can be a lengthy and expensive process, and sometimes getting the money that you won could be just as difficult, if not more so, than winning it in the first place. The details at this point start to get vague since both parties stopped commenting on it, but for one reason or another, All-Pro Sports Camp Incorporated and the Walt Disney Company settled out of court. It's possible that All-Pro felt that it was a faster way of actually getting a payout from Disney, or they could have decided that it wasn't worth the gamble of seeing it through appeals. Whatever the reason, the two settled for an undisclosed amount in September of 2002. One attorney who had defended theme parks in the past spoke with the Orlando Sentinel as an anonymous source and estimated that the settlement was probably in the ballpark of $10 million. They went on to speculate that after legal fees, Russell and Stratkick probably walked away with $2 to $3 million each. After an 8-year ordeal, the two had gone from being awarded what was one of the largest legal payouts from Disney in the company's history to what would likely amount to pocket change for Disney. But for Russell and Stratkick, it seemed like a choice between $240 million they might never see or a few million that they would actually walk away with. Meanwhile, whether or not they did use ideas from Sports Island, Disney still owns and operates the ESPN Wide World of Sports. It kind of makes you wonder, jury verdict aside, who actually won here?
We're flying to Disney's Riviera Resort with continuing flights to Epcot. Hold on to your straw hats. We are